Good morning, good afternoon, good evening, whatever time it is, wherever you're at right now. We want to thank you for tuning in to Conversations with Dr. Don. This show is produced and broadcast here in Portland, Oregon. My name is David Delk. I am a replacement for Dr. Don just for today while Dr. Don is away from the studio. For you first-time viewers, Conversations with Dr. Don is an ongoing series of one-hour standalone interview programs where we talk with interesting people such as yourself, who have something that they want to talk about. So we're going to be doing that this evening. Today our talk is mostly going to be on the topic of the U.S. Supreme Court's liberal turn. That's a question mark. And then we'll also talk a little bit about the Oregon legislative session, which just concluded. So our guest today is Dan Meek. Dan is a Portland public interest attorney. Has been a guest on this program before. I got to know Dan probably about 10 years ago when we were both working on the measures 46 and 47 to allow and to place into effect limitations on campaign contributions and expenditures here in Oregon. And so with that, welcome to the show.
Thanks, David. But, I thought we were going to talk about what the national media really thinks is important, and that would be the political philosophy and policy prescriptions of Donald Trump.
Okay, well, if you want to talk about that, you can, but I'm going to ask you questions about the U.S. Supreme Court.
All right. Well, all right.
So each Conversation with Dr. Don show consists of two major parts. The first segment is who are my guest and who am I? And we spend a little time getting to know ourselves. And so we can kind of appreciate what Dan has to say. The second segment is actually talking about the topic today. So let's get to know me a little bit and you a little bit, Dan. So I'll just go through a couple of things about myself. I'm a native Portlander. Born here in Portland 65 years ago. Not quite 65 years ago. I have probably another 2 weeks to go before I'm 65. I have a twin brother. I graduated from Portland State University. Started work on a master's in labor history, but financial situation didn't allow me to finish that. I have a partner, Tom. We've been together for over 20 years. I've now been retired for 3 years, which has been great. I'm president of the Portland chapter of the Alliance for Democracy. I'm on the state council of the Oregon Progressive Party. And I am generally regarded as an activist working on corporate domination issues, specifically on opposing so-called free trade agreements like the upcoming Trans-Pacific Partnership, and also promoting a 28th Constitution Amendment stating that corporations are not people and money is not speech. And so that's all I'm going to say about myself. So Dan, are you a native Portlander or Oregonian?
No, I was born and grew up in Pocatello, Idaho, in southeastern Idaho. I went to undergraduate school at the Educational Center of the West, University of Wyoming in Laramie.
Okay.
And since I went there, I was qualified for the HIC quota at Stanford Law School.
Oh.
Because they have to admit certain number of HICs every few years. They admitted me.
Was that the only reason they admitted you?
I think so.
Okay. I somehow doubt that.
I was at University of Wyoming, and I did okay there.
Uh-huh.
And so I've worked as a congressional staff director of a couple of congressional subcommittees in the 1980s. I've been in private law practice since 1986, 87. I generally sue utilities for cheating ratepayers and represent public interest groups in their causes. Mm-hmm. And I'm co-chair of the Independent Party of Oregon. I'm the authorized legal representative of the Progressive Party of Oregon. I have a partner, Linda Williams, for the past 33 years.
But who's counting, right?
Yeah,
Yeah.
33 years.
She probably is. Okay, all right, great. And you mentioned the two parties, the Independent Party of Oregon, the Progressive Party of Oregon. How is it you're involved with both parties?
Well, it all stemmed from, I think, a lot of things. It stemmed from the campaign that we did, you and I worked on in 2006 for campaign finance reform ballot measures in Oregon. And that caused me, basically the reason I got into that was because whenever I would win lawsuits against utilities for cheating ratepayers and breaking the law and require them to refund millions of dollars to ratepayers, utilities started just running over to the legislature to get the law changed retroactively in their favor and get my court cases thrown out. So that made me understand that campaign contributions and finance makes a big difference in Oregon, particularly where there are no limits on political contributions, where running for a seat in the Oregon legislature now in any kind of a competitive race often costs the winner between $600,000 and $1 million, and means that on a per capita basis, Oregon legislative races are the most expensive in the United States. So that's how why I got into the campaign finance reform realm. And now I've forgotten your question.
Well, I forgot too, but I thought that's all right. We can. Well, why were you involved with both the Independent Party and the Progressive Party?
In 2004, I helped out the Ralph Nader campaign in trying to get on the ballot in Oregon, and he was kept off by the retroactive invention of new rules pertaining to gathering signatures on petitions. And so I was watching what the legislature was doing after that when it came to how to get people on the ballot. So in 2005, they changed the law so that anyone who got on the ballot by petitioning, by collecting signatures, would no longer be identified on the ballot with the word independent next to her name, because the legislature thought, particularly the Democrats in the legislature thought, well, that sounds too good. Independent sounds strong, self-reliant. We're going to change that word on the ballot if, in case Ralph Nader goes out and collects signatures again to get on the ballot. The word next to his name on the ballot will be non-affiliated, which sounds like you're a loner, misfit, loser. You have no friends. You're non-affiliated. So once they did that, it occurred to me that the next thing they would do is try to clamp down and make it more difficult to create new political parties in Oregon. And strangely enough, since they took the word independent off the ballot as identifying any candidate, that released the word independent to be used as the name of a political party. So
because there's a rule in Oregon that a political party has to be named differently than other political parties, or the words can't be repeated or something?
No. There is a statute like that that's been ruled unconstitutional, but
I remember a case about one of the socialist parties.
The fact that the word independent would no longer be on the ballot as identifying a petition for candidate really just sort of cleared the field for being able to have someone on the ballot who would then be identified as independent party or independent, but with a capital I and meaning it's a nominee of the independent party. So the folks who collected signatures on campaign finance reform just kept going and collected the signatures for the independent party. And then in 2008, we went out and created the Peace Party of Oregon in order to nominate Ralph Nader in 2008, and then it changed its name in 2009 to the Progressive Party, which more, because it had broadened its horizon to issues beyond peace.
Okay, all right. Yeah, and so you've continued your involvement with both parties?
Yes.
All right, yes.
The Progressive Party is a minor party, and the Independent Party is now Oregon's third major party.
Okay.
And that introduces lots of complications.
Yeah. How many other states have three major parties?
Well, many states have a whole different structure. Many states don't register people by party at all, like Washington, for example. Other states don't have the distinction between major party and minor party. They just have ballot qualified party. There are about 6 other states that have a party named Independent Party. There are about 3 or 4 others that have a party named Independence Party. But as far as sort of large third parties, Vermont has some. Vermont has the Green Party in Vermont is quite large, and that's about it.
Okay. Yeah. Okay. Yeah. I just was not
Oh, and the
aware.
Progressive Party in Vermont as well.
Yeah. Right. Yeah. So, other civic organizations you belong to or active in, or?
Oh, lots. Besides those party, I help out this crazy group called Move to Amend.
Oh yes.
That is trying to get an amendment to the U.S. Constitution to overturn the horrendous Citizens United decision of the U.S. Supreme Court from 2010.
And of course, they're really trying to get more than just overturning the Citizens United.
Yes, the principles that they want to establish in the U.S. Constitution are that corporations don't have the rights of individuals, and that money is not speech and is not protected by the First Amendment.
Okay. All right. Great.
And I just represent all kinds of public interest groups.
Okay. All right. Great. People alive or dead that you admire?
Ralph Nader.
Ralph
is
Nader.
the central figure, obviously.
Mm-hmm.
Franklin Roosevelt, I guess. And in his retirement, Jimmy Carter. I think he's done a lot of good.
Yeah, Jimmy and
Mikhail Gorbachev.
Okay, that's an interesting one.
Well, he's probably one of the central figures of the 20th century when you think about it.
Well,
because
that's very true.
He's the one who basically released Eastern Europe, all of the Eastern European countries, allowed many of the Soviet republics to spin off and become their own countries, like Lithuania, Latvia, Estonia, and the biggest success is of course Turkmenistan.
Mm-hmm. Yeah.
And Uzbekistan.
Yeah. Right. Okay. Okay. How about a woman?
What?
How about a woman?
A woman?
Yep.
Elizabeth Warren, I would say.
Okay.
And,
Senator Warren.
Yep.
Right, from Massachusetts.
Right.
Okay. All right. Good. All right. So, anything else you want to share with us?
About me personally?
Yeah. Yeah.
Absolutely not.
You've already shared too much
already.
All right. So with that, we'll go ahead and we'll take a very short break, and we'll be right back. Yeah, that would be very good. Well,
Yes.
Thank you. We're back. Thank you for sticking with us. For you first-time viewers, Conversations with Dr. Don is an ongoing series of one-hour standalone programs where we talk with interesting people about who they are as unique, one-of-a-kind individuals, and about whatever it is we've decided to talk about. In this case today, we are talking with Dan Meek. He's a public interest attorney here in Portland, and the topic is the U.S. Supreme Court's liberal turn, ? And then we'll also get to some comments about the Oregon legislative session, which just ended. And I've lost a page of notes. Well, anyway, with regard to the U.S. Supreme Court, Dan, they had a number of decisions this last session, including the gay marriage, and there was another one on my list.
Probably affirming the subsidies in Obamacare.
Yes, the Obamacare, yes, which they did not throw out. And so there has been some comments that with a couple other decisions that perhaps the very conservative court is turning liberal.
Well, I would disagree with that, and let's start by defining liberal and conservative. There are, because those terms are bandied about and not used very precisely. I would say there's a big difference from being a liberal on social issues versus being a liberal on economic issues. And I think the term liberal on social issues probably applies to the archetypical swing justice Anthony Kennedy, also a graduate of Stanford, who often votes in what would be called a liberal way on social issues, and he did so in this session when he voted to strike down state laws against same-sex marriage. In fact, he wrote the opinion, and was found a sort of a new constitutional right to dignity, and applied it there. However, Anthony Kennedy is not a liberal when it comes to economic issues. That is, if the case involves something that affects corporations or affects businesses, he's not a liberal. He is a conservative in that he supports corporations, the rights of corporations and businesses over the individual. Mm-hmm. So in the same-sex marriage case, which was a 5-4 decision, the justices split in the way that you would ordinarily think. I mean, the conventional way, with the 4 liberal justices who are Sotomayor, Kagan, Ginsburg, and Breyer, all of whom were appointed by Democratic presidents, were joined by Kennedy, who was appointed by Reagan, as I recall. And the 4 dissenting justices were those appointed by the other 4 appointed by Republicans: Roberts, Scalia, Alito, and Thomas. And so it sort of worked out the way you would expect, with Justice Kennedy being the liberal 5th vote on a social issue.
Mm. And he is usually regarded as a swing vote.
That's right. He is a swing vote on most issues.
You're really saying, though, he's rather predictable, depending on whether it's a social or an economic
That's
case.
Right. That's right.
Okay.
The other case that got the most...
Let me ask you one more before we move on. Roberts is probably one of the more conservative justices, I believe, agreed with Kennedy on I think on both of those cases.
No, he did not.
He did not.
He did not vote with Kennedy to strike down laws against same-sex marriage. Because he is a social conservative. Mm-hmm. So, but the second case that got the most publicity in the usual news media was the case that King versus Burwell, that upheld the subsidies in Obamacare for persons who buy their health insurance through the federal exchange and not through state exchanges. And it turns out that the law itself, that was passed in 2010 in 7 different places, says that the tax credit subsidy, is available for those who buy health insurance through a state-established exchange. And the law in many other places refers to the federal established exchange. Mm-hmm. So if you read it literally, probably if you do read it literally, the conservatives, the 3 who voted to strike down the subsidies, Scalia, Alito, and Thomas, probably have it right. But both Kennedy and Roberts voted not to strike down the subsidies because they just felt that the specific language should be overridden by the overall purpose of the statute, so they certainly took a non-literal approach to that. Mm-hmm. And when you consider what economic interests are at stake, of course, the insurance companies were very much in favor of the subsidies, because that's money for them. Sure. Mm-hmm. And the medical care corporations were very much in favor of it because that's money for them. Mm-hmm. So Kennedy took the position that was most beneficial to corporations.
Mm-hmm. Okay.
Now, there are other cases that I think illustrate this even better. A very important case that didn't get much publicity was the case in which the Supreme Court struck down in 3 cases, struck down the Environmental Protection Agency's rules implementing the Clean Air Act, particularly for emissions of mercury and other toxic pollutants from power plants. Those are also 5-4 decisions in which Kennedy voted with the conservatives because, as I pointed out, it's an economic issue. It affects corporations and utilities, so he voted with the conservatives. The case said that the EPA's analysis in adopting the rules and regulations was faulty because it didn't consider the cost of controlling mercury and the other emissions, and that it should have considered the cost in addition to the benefits. So that'll go back to EPA. They can consider the cost and benefits. They can come up with the same substantive rules that they did before, but it will take several years for that to happen. Mm-hmm. And if a Republican president gets into office before then, it'll probably never happen, and the pollutants will continue to be emitted. Mm-hmm. So that's not too liberal, is it? It doesn't sound too liberal.
No.
A very important case that got very little or no publicity in the lamestream media, as our favorite former Alaska governor would say, was Arizona State Legislature versus the Arizona Independent Redistricting Commission. Arizona voters by initiative about 5 or 6 years ago adopted an amendment to the Arizona Constitution that that established an independent commission for redistricting both seats in the Arizona legislature and also seats in the U.S. Congress elected from Arizona, the representative seats. And it didn't really set up a very independent mechanism. The 5 people on the so-called independent commission are 4 people appointed by legislative leaders, plus 1 person selected by the other 4. So nevertheless, the Arizona legislature didn't like what the commission did because the commission didn't protect incumbents as much as the legislature would have done so, and didn't engage in as much gerrymandering as the legislature itself would have liked. And so the legislature itself filed a lawsuit against the commission.
Really, the legislature
Right,
did?
saying that under the U.S. Constitution, for congressional offices, that a state cannot change the way folks are elected to Congress by initiative, because the U.S. Constitution says that the districts shall be set by the state legislature. Mm-hmm. Well, in Arizona, ever since it was created, its first constitution was about 1910. It was one of the very last states to enter the Union. Its constitution has the initiative process, as Oregon adopted the initiative process in 1904. And what the Arizona legislature argued was that when the U.S. Constitution says something is to be done by the state legislature, it means the sitting legislature of elected representatives, and it doesn't mean any other legislative process that the state might have. So this case was...
Sorry, this is what the Arizona legislature is saying now.
That's what they said, yes.
Right.
And what the U.S. Supreme Court said in a 5-4 decision, with Kennedy voting with the liberals, said that no, what the Constitution, or what the U.S. Constitution often means when it refers to state legislature, is whatever legislative process that the state has, whether it's a sitting legislature of representatives or the initiative process. Mm-hmm. And so they upheld that Arizona initiative that took redistricting and moved it away from the legislature and into the hands of a so-called independent commission.
And in Arizona, in their constitution, does it say that the people using the initiative process are equal to the legislature, or something along that line?
I don't know that it says that. It says that the people using the initiative process can adopt legislation. Mm-hmm. In Oregon, we have a special clause in our Constitution that says whenever the Oregon Constitution, for example, refers to the Legislative Assembly, it means not only the folks sitting in Salem, but it means the people using the initiative process.
Right. Mm-hmm.
So, this case was important for a number of reasons. One of them is that the state of Oregon has been keeping ballot measures off the ballot and refusing to give them ballot titles and refusing to allow folks to collect signatures, with the argument that, well, for example, in the case of Move to Amend, which is trying to have a statewide ballot measure to put Oregon on record as calling for a constitutional convention to adopt a constitutional amendment that money is not speech and that corporations don't have the rights of people. The Oregon Attorney General and Secretary of State have said, no, you can't even put that on the ballot because the U.S. Constitution says that calls for constitutional amendments under Article 5 of the U.S. Constitution can only be done by the state legislature. Mm-hmm. Well, we are arguing in court that doesn't mean the sitting legislature in Salem. It means whatever legislative process the state uses, mm-hmm. and that's what has been now upheld by the U.S. Supreme mm-hmm. Court. So
yeah, so far as we're concerned, this is a really important decision that's gotten virtually no.
It's a very important decision, and the language in it is important too, because the language is extremely laudatory toward the initiative process and how important it is to have the initiative process to overcome the entrenched power of the legislature and moneyed interests, et cetera. It's really kind of a populist manifesto, mm-hmm. which is curious because of the 5 justices who voted for it, 3 of them sort of took the opposite position a year ago in the Hollingsworth versus Perry case, which struck down California's ballot measure, which outlawed same-sex marriage. You may recall that the Supreme Court a year ago struck down that measure, not because of anything having to do with same-sex marriage. It struck it down on a procedural ground because after the people of California adopted this horrendous measure, horrendous as it was, the Attorney General of California refused to defend its constitutionality in court.
Right. Mm-hmm.
And so the proponents of the measure said, well, we want to defend the constitutionality in court. And the Ninth Circuit said, no, you don't get to do that. Go away. Mm-hmm. Nobody gets to defend its constitutionality if the Attorney General of the state decides not to. And that's what the U.S. Supreme Court upheld a year ago. That's a very dangerous decision.
Well, yeah, that essentially means that, was it the Secretary of State? That, at least the Secretary of State essentially gets to decide what laws they do or they don't want to enforce.
The Attorney General gets to decide that.
I'm sorry,
and
yeah,
so
right.
It really, if that persists, that's going to be a tremendous harm to the initiative process, because by definition, people do by initiative what the political establishment doesn't want to do. Mm-hmm. So every measure adopted by initiative is basically something the legislature wouldn't do, mm-hmm. and conventional politicians wouldn't do. So the Hollingsworth versus Perry decision says that, well, if the Attorney General of the state doesn't want to defend the constitutionality of a measure adopted by initiative, then nobody gets to defend it, which means obviously the side arguing that it's unconstitutional has a big advantage. Mm-hmm. And it means that a lot more measures will be found unconstitutional. Mm-hmm. In Oregon, where this situation has occurred, the chief petitioners have been allowed to argue that the thing is constitutional, but that could change. So, mm-hmm. but it's in the Hollingsworth decision, the folks who voted in a way that really diminishes or tends to destroy the initiative process were Justices Kagan, Ginsburg, and Breyer, 3 so-called liberals. Uh-huh. So one might say that their votes in both cases were outcome-oriented. That is, mm-hmm. they look more at the outcome than the sort of the nuts and bolts of the decision and the implication on other issues. Mm-hmm. But it's really too bad that the cases came up in that order. That is if the same-sex marriage cases had come up in the opposite order, you would never have to get to the situation where you destroy the initiative process by not allowing anyone to defend the constitutionality of an initiative.
Great. Okay. So what else has the Supreme Court been up to?
Well, another decision that has hidden negative implications is Reed versus Town of Gilbert, Arizona, which I'm sure you're very familiar with. You've heard of that.
I've never heard of it, frankly.
Well, that town adopted an ordinance about signs. And they said, okay, you can have political signs up for this period of time, you can have commercial signs up for this period of time. If they're directional signs, like to a wedding or something, you can only have it up for 12 hours before the event and only 1 hour after the event, a bunch of stuff like that. And so that was challenged in court as a violation of free speech.
Arizona certainly does look
get a lot
into
of
things
cases.
that are really, really important, don't they?
They get a lot of cases.
Yeah.
So the decision striking down that law as a violation of free speech was 9-0.
Really?
And the majority, it was really 6 justices, took the approach that you can't have any of these restrictions you can't have content-based restrictions on signs or speech. Kagan, Ginsburg, and Breyer, the same 3 I mentioned before, said that goes too far. But when you think about it, if you can't have content restrictions on signs, you probably can't have content-based restrictions on political advertising either, right? Mm-hmm. So let's say Oregon, like 8 other states, adopted a law that said, in every political ad that you put out, you have to identify the major contributors to your campaign that's funding the ad, or the major independent expenditure folks who are paying for the ad. That's I think has been determinative in some elections in California since it was adopted about 3 years ago. Well, that's a content-based restriction on speech. Mm-hmm. You're only applying it to speech that advocates for for or against the candidate or for or against the ballot measure. So that's a very potentially dangerous decision that nobody in the majority opinion or the concurring opinions recognize that at all. So there's also several lesser important cases, one of which you probably also haven't heard of, Walker versus Texas Division of the Sons of Confederate Veterans. Those folks wanted to have the state produce a Confederate flag as a license plate.
Oh, I have heard of this one. Yes.
Because the state allows all kinds of license plates, for like Oregon does. It's got a fish, it's got Crater Lake, it's got other things. But the U.S. Supreme Court said that license plates are government speech, and the First Amendment doesn't apply to those. So basically, the government can make decisions on what to allow on license plates. It doesn't have to be fair about it.
And did Texas have some kind of procedures for making decisions on it, or
it had
were
procedures.
they arbitrary about it?
It had procedures, but the reason that the Texas officials gave for not allowing the Confederate flag on plates was that the Confederate flag was offensive, sort of a subjective thing. But the Supreme Court said by 5-4 that's okay, and it was weird because of who provided the fifth vote.
Who?
Clarence Thomas.
Clarence Thomas.
Yeah, so it was the 4 liberals and Clarence Thomas. I don't know that has ever happened in the last 20 years that Clarence Thomas has been on the court. 23 years that he's been on the court. So those are just some of the lesser known decisions. And I think the first few that I mentioned are the ones that have the greatest impact for mischief. Oh, one other one is that in Williams-Yulee versus Florida Bar, Supreme Court, another 5-4 decision, upheld the Florida statute that forbids candidates for election to judge, from soliciting contributions. That's obviously a very direct restriction on speech. It says you can't solicit contributions. It doesn't say you can't receive them, but it says you can't ask for them. Oregon had a similar statute that the Oregon Supreme Court upheld against all challenges, including challenges under the Oregon Constitution, in about the year 2000. And so now the Supreme Court has upheld it. 30 states have these bans on personal solicitations of campaign contributions in judge races. And the other interesting thing is who provided the 5th vote for that decision. Well, it was 4 liberals and John Roberts this time, not Kennedy.
So why would he be particularly concerned about this?
I think that Chief Justice Roberts is less ideological than the other judges and more, he thinks about the implications and the political implications of things. He's a far more political judge than an ideological judge. And I think that's why he voted for, to keep the subsidies in Obamacare, and also voted to keep the restrictions on judges soliciting contributions. Just because judges soliciting contributions from the same, and getting them from the same attorneys who appear before them, it looks really bad, or obtaining contributions from big corporations that have very important cases in front of them looks bad. And so he walks kind of a fine political line. He doesn't sort of push the envelope the way Scalia, Alito, and Thomas push the envelope in a much more ideological way. Sort of damn the torpedoes full speed ahead for those guys.
Okay, all right. So let's go on to the Oregon legislature. But again, your kind of summary of what the Supreme Court has done is they divide based on whether it's a social issue or an economic issue.
Right.
And so it's not really a turning to a liberal direction on the part of the Supreme Court, but reflects the kind of decisions that
Well, it reflects the kind of cases that came up this time.
Right.
There were more social issue cases in this session than in previous sessions.
Great. Okay, good. Yeah. So the Oregon legislature finished their session a couple weeks ago, and we were hoping that they would do a couple things. One of them, of course, was that Governor Kate Brown, when she was Secretary of State, introduced a bill to the legislature to allow limitations on campaign contributions. Talk about that.
Right. That was Senate Joint Resolution 5, which would basically overturn the decision of the Oregon Supreme Court in 1997 that said that somehow the Oregon Constitution does not allow limits on political contributions. No other state has ever interpreted its own Constitution as saying that. The U.S. Supreme Court has never interpreted the First Amendment as saying that. So the Oregon Supreme Court did so based upon Oregon's Article 1, Section 8, its free speech clause, which is the same free speech clause that exists in 37 other states.
But I always hear that Oregon's free speech clause is so much stronger than every place else.
It's exactly the same, maybe with one word different. That is, refers to, writings instead of documents. It's this, but it's the same as 37 other states. It was copied from, when the Oregon Constitution was drafted back in 1857, they didn't write a whole lot of new stuff because there were other constitutions out there to borrow from. And they in particular borrowed from the constitutions of the southern states, the pre-Confederate southern states. In particular, as I recall, Kentucky, Alabama, all those states had very populist kind of constitutions, and that's what they borrowed from. It's often said that the Oregon Constitution is based on like the Indiana or Wisconsin constitutions, but in fact, those constitutions were also based upon the pre-Confederate constitutions of the southern states.
Okay.
So to overcome that, which I've called, that decision of the Oregon Supreme Court, I've called Citizens United on steroids. Kate Brown introduced Senate Joint Resolution 5, which would allow in Oregon, which would amend the Oregon Constitution if approved by voters to allow limits on political contributions in state and local races. And that bill in the legislature had the support of many very important groups like the Oregon Progressive Party and the Independent Party of Oregon, Common Cause, Augsburg, League of Women Voters, all sorts of others. And so it went to the Senate Rules Committee, and then went nowhere. They had a hearing and then did absolutely nothing with it. Common Cause really spearheaded the bill in the legislature, and they said that they had lined up a majority of senators to vote for it on the floor of the Senate and a majority of the House members to vote for it on the floor of the House. But since the Democratic Party is in control of both houses this session, it was up to the Democratic Party leadership to either allow it to go to the floor of either House or Senate or not, and they decided not to let it go to the floor, not even to allow a vote in the Senate Rules Committee. So nobody took any votes on it, no fingerprints on killing it. Somebody killed it, but there are no fingerprints on the murderer.
But yet, the common perception is the Democrats are in support of limiting campaign contributions.
What?
This is the common. People usually express surprise when we tell them that Democrats, in fact, don't support limiting campaign contributions.
There have been numerous Oregon legislative sessions where the Democrats have majorities or supermajorities in both the House and Senate and a Democratic governor. In none of those sessions ever, even once, in its entire history, has the Oregon legislature adopted a limit on political contributions. The voters have adopted them 4 times, but the Oregon legislature never has. There were several instances in the 1990s when that was the situation, and of course that's the situation in this session. In the past, in the previous session, Democrats had majorities in both House and Senate. They have even bigger ones in this session, but campaign finance reform doesn't even get out of committee. It doesn't even get a vote in committee because they don't want to do that. They want to claim that they're in favor of it, but they never do it.
Yeah. Okay. And what she had proposed was actually pretty limited.
It would only have allowed limitations on contributions in candidate races. It wouldn't have applied to ballot measure campaigns, and it wouldn't have done anything to sort of loosen the stranglehold of the 1997 Supreme Court decision when it comes to independent expenditures, which would leave Oregon with a Citizens United type of regime of unlimited independent expenditures, even if and when Citizens United is overturned by the U.S. Supreme Court. Citizens United was in 2010 decision was only 5-4, and the next appointment of a justice of the Supreme Court could well result in its reversal. Citizens United itself reversed the McConnell decision on the subject of independent expenditures being banned for corporations and unions that had been decided only 3 years earlier. So, it's very much in flux and very much depends on who's on the court, which very much depends on which Supreme Court justices die, basically, or become incapable of, obviously incapable of serving. Of the 3 oldest Supreme Court justices at this point, 2 of them are conservatives when it comes to these kinds of issues, and that is Justice Scalia and Justice Kennedy. The oldest justice, 82, is Ruth Ginsburg. So it depends on whose term on the Supreme Court ends first, whether Citizens United gets reversed, and then Oregon should not be in the position of saying, well, yeah, the rest of the country isn't governed by Citizens United, but we still are. But in any event, Senate Joint Resolution 5 would have done something. It would certainly have been progress, but it doesn't even get a vote in committee. That's how the Oregon legislature treats it.
So on this particular issue, what are our steps forward, or do we have steps?
Well, we can once again do a statewide ballot measure to authorize limits, and that's something that we have underway. In cooperation with many of the other groups that I mentioned, and there will most likely be a statewide ballot measure for November 2016 on this. We can also try adopting limits on campaign contributions in local races. There is a Multnomah County initiative currently on the streets in order to do that for all campaigns that are all candidate races that are administered by Multnomah County, which includes all Multnomah County races plus City of Portland, City of Gresham, various districts inside of Multnomah County. Folks can learn more about that by going to progparty.org, and there they can also find much detailed information about the 70 bills that the Oregon Progressive Party supported in the past legislature, 15 of which passed for a success rate of 20%. The Progressive Party also opposed 21 bills, but 8 of them passed, which is a failure rate of 40%. So more failure than success. Just one other thing on campaign finance reform I'd like to mention is that the Center for American Progress, which is also considered to be a very left-leaning liberal type organization, just within the past month did rankings of the states on various criteria. One of them being, influence in the political system, meaning that the state has taken steps to reduce the influence of big money on the political system. And the grade that they gave to Oregon is D-. And so this is one of the nation's leading liberal organizations giving Oregon a D- when Oregon government has been in the control of Democrats for quite some time. The Oregon legislature did create a task force of like 16 or 17 people, a campaign finance reform task force, to be appointed conveniently by the legislative leaderships in the House and Senate of the Oregon legislatures. That'll work well. And by the Secretary of State, well, it remains to be seen.
Yeah,
but
it's not like they haven't had decades to address this already.
That's right, and they've had task forces before, and none of which have accomplished anything.
Yeah. I see that there was a bill that would have required disclosure.
Various bills in the Oregon legislature would have required much more effective disclosure of campaign contribution sources in Oregon. One of them was sponsored by Bill Kennemer, a Republican from the Oregon City area in Clackamas County, House Bill 2316. And that would have required all political ads to identify their top 3 funders. So when you saw a political ad for any candidate, it wouldn't just say, paid for by the committee to support whatever or whomever. It would say, and my 3 biggest contributors are Portland General Electric, Georgia Pacific Corporation, and and whatever, some other forest products.
Yeah. Oh, right. Yeah.
And Aetna Insurance or whatever. It would give, and a bank. So that would give voters far more information. It would also very much offset the influence of big money, because if you have to identify the source of your money, how effective is a candidate ad that says, vote for me, I'm a great family guy, here's my dog, here's my kids, and oh, by the way, my biggest contributor is Walmart, or my biggest contributor is the, Altria, which is formerly known as Philip Morris, Yeah, tobacco companies are my biggest contributor. But Oregon legislators have that, but they never reveal it. They never have to put it out in ads. Instead, in the Oregon system, you simply report it after the fact on the ORSTAR system. And even then, you don't have to identify who it really is. For example, many candidates get contributions from Oregonians for food and shelter. Well, that sounds great, right? Must be a very public interest group or something. No, it's a political action committee consisting of the forest products company and chemical companies. The biggest ones are Monsanto, Dow, DuPont, and the various Koch Industries, the various forest products companies and chemical companies. So the other thing you need to do is require political committees to identify themselves in a way that accurately indicates their economic interest. And California passed a law to do that, and Montana's passed a law to do that. So, of course, bills like this, the Kennemer bill, went absolutely nowhere. It got a 5-minute hearing at which Bill Kennemer and I testified for it, and that's it. Okay. There was also another bill that went through a whole bunch of hearings about changing the time periods for reporting political contributions, and it ended up having everything stripped out of it except the political campaign finance task force. So basically, they got totally destroyed.
Yeah. So quickly, because we're about 8 minutes left before we conclude this program, talk about some of the ethics bills. Obviously, they were that governor.
Governor Kate Brown. Governor
one,
John Kitzhaber.
Had some ethics problems and was forced to resign. I don't know.
Yes.
He did resign.
But he did resign
right.
because of ethics concerns, and you would think that would be an opportunity for the Democrats to really go for ethics reform. For example, when a similar thing happened in Arizona about 20 years ago, the Arizona legislature got busy, and the folks got busy, and they actually enacted public funding for campaigns. But so in the Oregon legislature and in the press, there was all sorts of talk about ethics reform bills, and that Kate Brown got through her ethics reform bills. But if you look at them, they're not really ethics reform at all. One of them was simply requiring that the Secretary of State audit the practices of agencies in responding to Public Records Act requests. That just means you look at the practices and you write them down. Okay, they take 6 months to answer a request. In Oregon, that you can take an infinite amount of time to answer a Public Records Act request, by the way, because there's no deadline. Also, agencies can destroy records whenever they feel like it, basically, most of them. So instead of having anything substantive, like you have to keep records and you can't destroy them, and you have to respond to requests within 30 days or something, all that the bill did is say, the Secretary of State has to look at list their practices. The other so-called ethics reform bill said that if the governor has a partner, then that partner is designated as a public official. Well, that's hugely significant. Sylvia Hayes was already designated a public official. Okay. Also required that the Oregon Government Ethics Commission complete their preliminary review of complaints faster than they do now, within 30 days instead of 130 days. Okay, that's good, but it's no big deal. It doesn't change the ethics laws. It just says, process them faster. And finally, the other ethics bill was banning statewide elected officials, the 4 or 5 of those, from accepting honoraria for giving speeches. Well, I don't recall that that's a big problem. It certainly wasn't anything that Sylvia Hayes did or John Kitzhaber did. But what's interesting is that the Democrats absolutely rejected several 8 very meaningful ethics reform bills that were introduced by Republicans, strangely enough. In the Senate, there was a bill that made vote trading illegal. That is, saying that making it illegal to vote in any particular way based on future promises of campaign contributions. Okay. Another bill would have required that high-ranking agency and elected officials would be placed under oath when testifying before the legislature. So they have to tell the truth.
That seems like it should be a given.
It should be the law. It is the law in Congress. I know that when I worked in Congress, witnesses are put under oath. And so if they don't tell the truth, they're responsible for that. Another bill which makes it illegal to submit false information in the voter's pamphlet, like describing yourself as a candidate falsely. All of those bills were defeated on straight party line votes in the Senate, 18-12, with all Republicans voting for them and all Democrats voting against them.
Wow.
The only reason they got to the floor, they couldn't get votes in committee even, is that the Republicans used a technique called withdrawal, where any member of the body can go to the floor and say, I move to withdraw this bill from committee, where it's bottled up, to the floor of the Senate in this case, for a vote. And so under the rules of the Oregon Senate, that motion is automatically in order and has to be voted on. And so that's what was voted down on straight party line votes. In the House, they did the same thing. The votes were not straight party line. 1 or 2 Democrats voted for these ethics reform bills on the House side. All of the Republicans voted for them, as I recall.
So I would bet that one of the Democrats was Betsy Johnson.
Who voted for or against them?
Against.
Voted against. But then nearly all the Democrats voted against.
Oh, I'm sorry. So
the Republicans
voted for.
I know. I can see how it's confusing to you that the Republicans are the ones who are voting for ethics reform.
Yes,
right. The Democrats were the ones who were voting against it. But that's the way it was. Those bills in the House were the Legislative Assembly could appoint a special counsel to investigate the governor instead of the Attorney General. In this case, you may recall that the Oregon Attorney General took until the middle of February of this year to announce that she was going to investigate John Kitzhaber. That was pretty late. And then a week or so after her investigation was announced, she announced that she was just closing the investigation and not going to do it because she was requested to close it by the Federal Justice Department, who was going to do the investigation instead. So I think having an independent counsel would have been useful in that situation.
Okay, yeah. So we unfortunately have run out of time again.
All right.
As you and I usually do. So thank you very much for being here.
But it says 2 minutes.
Yeah, right. And I'm going to take that 2 minutes. So we've got a few things to close up. And so keep your pens and pencils handy because you might want to jot something down. One of our organizations that Don really likes, that I really like because I'm the local president, is the Alliance for Democracy. You can learn more about the Alliance for Democracy at thealliancefordemocracy.org or our Portland website at afd-pdx.org. And we are, let's see, the Alliance for Democracy is concerned with ending corporate domination and establishing true democracy. So we get involved with a lot of these things that we've been talking about today with Dan. Let's see, what else we got? To get Dr. Don's local broadcast schedule, go to www.donbayham.org.com and then click on present day activities. And next, to watch his shows on the web, go to Dr. Don YouTube, click on a particular show. And you can learn more about the ACLU at aclu.org, and there's their phone number. To get Dr. Don's programs broadcast at other stations, ask your local public access station to go to pegmedia.org and then follow the instructions. And to learn how to end corporate personhood and amend the Constitution, go to movetoamend.org. And so thank you for watching, and remember, KFC. No, not that KFC, Dr. Don's KFC. Kind, friendly, charitable. Be kind, be friendly, and be charitable. To you too, all of you.